They haven't assessed any of the evidence that we've presented. They haven't listened to survivors, but yet we are presented as biased and in the echo chamber. They live in their echo chamber. They cannot afford to hear the people who are pointing out what they're doing because they would have to rethink their entire lives. And they're not going to do that.
This is the Wall of Silence podcast, the ACNAtoo story, an account of church abuse and cover-up in the Anglican Church in North America, of things done and left undone, and why we should care about it. This is episode 17, Due Diligence, Reactions to the Ruch Verdict, Part 1. A few days after Christmas, on the feast of St. John the Apostle, I gathered with members of ACNAtoo on Zoom for a discussion with their reactions to the verdict from Bishop Stewart Ruch's presentment trial, handed down by the Anglican Church in North America's Court for the Trial of a Bishop on December 16, 2025. This episode is part 1 of 2 episodes, with part 2 featuring ACNAtoo answering questions from listeners and supporters who were present during our Zoom recording. The court's verdict declared Ruch acquitted on all charges. As a way of backing up their verdict, the trial court's final order stated, using the testimony of main witness Teresa Sidebotham, quote, that there was no leadership culpability on the part of Bishop Ruch, no substantiated allegations of misconduct or canonical violations, and no evidence that diocesan structures failed because of any action or omission by him. The diocese's trajectory from parish-based safeguarding toward diocesan standardization reflect normal institutional growth, not episcopal negligence. End quote, again, from the trial order, which will be quoted at length at various times throughout my intro and outro of this episode. Within their final order, the court shifted blame to the institution of the ACNA itself, that is, the leadership within the province, as well as, quote, a narrative driven largely by social media, end quote, especially of advocacy groups like ACNAtoo, where provincial leadership was, quote, motivated by a perceived need to give them something, with Bishop Ruch becoming the focal point, end quote. Later, the trial order also said the charges against Ruch were rooted in developing bias, driven not by new factual finding, but by external advocacy pressure. In the next paragraph, the trial order states, quote, many allegations against Bishop Ruch were unreasonable, vindictive, or rooted in theological disagreement, that much of what was posted online was demonstrably false, end quote. And thus, to use a phrase from the order that has become much discussed since it was released, it would seem, according to the trial court, that the reason there was any presentment against Bishop Ruch at all is that many within the ACNA had fallen victim to, quote, narrative capture, end quote, from the online pressures and manipulations of the facts from ACNAtoo. But I commend you, my listeners. Go read the trial order. What accusations did they spend any amount of time on actually proving to be demonstrably false? Did the trial court demonstrate they acted in good faith, and did their due diligence in examining the evidence presented against Stewart Ruch? Instead, if you lay their narrative beside the work of ACNAtoo as found in the timeline they've compiled on their website, along with what is laid out in the 2 presentments against Ruch, you hardly find the trial order going into any evidence at all. As always, the details are many and layered, which is why I recommend going to the show notes for this episode, where you will find links to the trial order, ACNAtoo's comprehensive timeline on their website, the text of the 2 presentments, and more recent articles covering the case. Along with all this, other issues arose in the ACNA in December 2025, namely another Washington Post article where acting Archbishop Julian Dobbs was accused of financial impropriety, along with a former ACNA bishop, Derek Jones, who led a chaplain-based diocese called Jurisdiction of the Armed Forces and Chaplaincy, and is now facing his own presentment trial, assuming he would submit to that process. And, again referring to Bishop Jones, who has now formed a breakaway Anglican denomination, the Anglican Reformed Catholic Church. Adding to this messiness, Jones is also suing the ACNA for trademark infringement. Going into the details of these 2, or perhaps 3 or 4 major developments is beyond the scope of this episode. But again, check the show notes in your podcasting app or the transcript page for this episode on ACNAtoo's website with a list of article links. As a way of leading into my conversation with ACNAtoo, I want to point to one simple example from the trial order that should put the court's due diligence in serious question. Here is some audio from later on in our discussion where I bring up a point brought up in the trial order that didn't sit well with me. It's almost not even important. In the scheme of things, this example is like, but it shows how the trial court itself didn't do their due diligence, or something. Maybe they willfully abandoned this particular detail. Based on what we know, when Stewart took a leave of absence, it was not a voluntary leave of absence. It was actually administered maybe by request or direct order from Bishop Alan Hawkins. Helen Kuning notes this in her own articles that she's written for ACNAtoo. The trial order, the official ACNA trial order, says that Bishop, on his voluntary leave of absence, if they would have just simply looked into actual testimony, this was their time, this was their chance to just make simple factual acknowledgments of, actually, Bishop Ruch didn't actually take a voluntary leave of absence. It was ordered from Bishop Alan Hawkins, They didn't do that in the trial order. And this is what they released as what we're supposed to take as the official response for the trial. That's just one detail that was not directly about one of the survivors, right? Or the case with Rivera, or the people that Bishop Stewart hired or had others hire under his tenure. That's just one little thing that's evidence of the process that they have gone through. What did Helen Kuning say in her article? Allow me to read from it at length. She says, technically speaking, Bishop Stewart Ruch is on a voluntary leave of absence. What is left out, however, is that he was, in fact, asked to do so by Bishop Alan Hawkins at the behest of Archbishop Foley Beach. I, meaning Helen, was in the Zoom meeting on the morning that this was announced to the BC, that's the Bishop's Committee, and the deans by Bishop Stewart and Bishop Allen. I believe that Sharon had gone on Twitter and posted her story the day before. Bishop Allen had called Bishop Stewart earlier that morning. They had discussed the matter privately, and now they were coming forward jointly to tell the BC that we were to be the, quote, ecclesiastical body in the Upper Midwest Diocese, UMD, during Bishop Stewart's absence. A couple of paragraphs later, Helen continues by saying, Bishop Stewart was asked by Bishop Allen to draft an official announcement of his leave of absence, and it was published after the province approved it. The BC was asked to draft an email requesting help from the province. We did, and Archbishop Foley responded to this request quickly. The public communications from both the UMD and the ACNA have been that Bishop Stewart's leave was and continues to be, when she wrote this article, completely voluntary, and imply that it was self-initiated and continues to be self-imposed. Helen continues by saying, as a first-generation Chinese immigrant, I understand the desire to, quote, save face. But I thought at that particular time last July, and still think today, that I was being asked to perpetuate a falsehood every single time I had to agree, or at least not openly disagree, with the statement that Bishop Stewart had chosen to step down from his position completely on his own volition. My question, are we acting in a fully transparent manner? Or are we creating a culture of image management and false perceptions? Moving on from her article, I could add to her questions. In a trial plagued with controversy and confusion, leading anyone paying attention to question its very process and procedures, as well as the qualifications and necessary impartiality of those serving on the trial court, have they shown us they've done their due diligence in gathering and covering all of the evidence necessary to give Bishop Stewart Ruch a full and fair trial? In looking at this simple instance, as to whether or not Bishop Ruch went on a voluntary or imposed leave of absence, Whether it was instituted by Bishop Alan Hawkins through the insistence of Archbishop Foley Beach, or did he do it of his own volition, I would say it's evident due diligence was not a high priority for the trial court. With this question as our underlying principle, let's turn now to my conversation with ACNAtoo. Joining me that day were Abbi Nye, Audrey Luhmann, Heather Griffin, and Whitney Harrison. Today is a chance to do another recap as we have received the verdict from Bishop Stewart Ruch's trial. I think what's difficult about this, and I was realizing it today as I was reviewing notes and looking at the trial verdict, is we could take this 2 pages at a time and we could go through, hey, today we are going through pages 1 to 2 or 1 to 5 or whatever we would do. And we could just take an hour and parse through every single detail of the trial record, the order, whatever you want to call it. We've all spent so much time on this already. I also realize this, speaking of narrative capture, as has been maybe it's the buzzword from the verdict, is I see that there's this vast disparity between people who might say, we don't understand why there even was a trial. This is just a bunch of people out to get this guy. They're against his theology, all these things. An argument about even the legitimacy of having the trial itself versus on the other side, as I've had friends say to me, what are we talking about here? This is somebody that would have been fired from a local teaching administration job or some kind of other similar position, even at a much lower rung of authority. That what has happened under Bishop Stewart Ruch's tenure is way less than most people would ever endure before getting fired. We have this vast disparity. So, Abbi, I want to leave it over to you. You have a good list of here's what we want to cover. Here's why we're going over this today.
Yeah, as you were saying, some people may wonder, why are we even bothering to discuss this? And I think that's a legitimate question. Certainly, there are some online who want to dismiss this as ACNAtoo is unhappy with the verdict. But I hear a couple of reasons why I think it is useful for us and for the ACNA at large to discuss the Ruch verdict. And the first of those reasons is that we have 2 more trials coming up. First, Steve Wood. And I think that is going to be the most important one. How the Ruch investigation and trial process was handled gives us precedent for how Steve Wood's trial might be handled. Derek Jones is probably a different situation. I doubt he'll even show up for the trial. He'll probably be tried in absentia, and so that will be a separate issue. So we've got more trials coming up. We also have Title IV revisions that are in process. And I think as a lot of people look at the Ruch verdict, there are things that you will see that you're like, well, that's weird. Why was it done that way? And the new Title IV revisions can address some of those questions. And so I hope that people who are listening to our conversation today will take this information into your thoughts about Title IV. And certainly we would encourage you to participate and to give your feedback because there are several rounds of feedback going on here. I also want to just call attention to the fact that, as we look at the final order, we see this was a really expensive process to the point where a couple of bishops lent the province money or offered to lend them money. So this is your tithe money that is funding this. And I think it's really important to take, that seriously, to realize that, as your money is funding this process, you have a right to ask questions and to review what happened. And we certainly want to provide a way for you to do that. And then I think the fourth reason, and the one we'll spend the most time on today, is that we see so many issues with the verdict. And, certainly there have been various entities online who have started calling that out, especially on Substack. There have been some good posts lately, but there are a lot of different things that come up with the verdict that need to be discussed. And so those are 4 different reasons why we're here today and that we're thinking will guide our discussion.
So let's start with where I begin my episodes of The Wall of Silence. I have been giving a disclaimer. I have said, hey, listen, if you have a conflict of interest where if you were to listen to this episode of The Wall of Silence, it would put in jeopardy your role in the trial. Don't listen to this, right? I will admit something. There has been it's been somewhat ironic how I've been delivering that disclaimer. Part of it was because my own former bishop told me I was in a conflict of interest by making the podcast. But it was also coupled with that it's apparent those that were on the trial or who helped to formulate the trial, the tribunal, you guys can use the correct words, that it's just rife with conflicts of interest. At the risk of throwing out names upon names, who wants to address some of those conflicts of interest and how, when you look at the verdict itself, like what they're presenting, that the people involved also present a problem? How might some of you describe that?
I can't remember. I made a list of some of the potential conflicts of interest. From the very beginning, Alan Hawkins was made the leader, basically the chair of the provincial response team. He had worked very closely with Stewart Ruch for years on the Anglican 1000 initiative, which then became Always Forward, which Alan passed down to Dan Alger and Stewart passed on to his sister-in-law, Molly Ruch. So it was really strange, even from the beginning, for us to see that and go, oh, the guy who's like setting up the response team is somebody who has worked closely. I can't speak on their relationship, but they have worked closely together. They put a bishop, Eric Manise, on the provincial response team that we had heard was a friend of Stewart's, and then we have since seen evidence of him meeting with Stewart pretty repeatedly through the leave of absence, after the leave of absence, even just prior, like 2 weeks, maybe prior to, or 3 weeks prior to the trial hearings. I mean, who wants to keep going? Abby, do you want to read the screenshot of Quig Lawrence?
Yeah, let's see here. One of the interesting things about the trial was that the trial court is the way it's set up is that there are people on the court and then there are alternates in case someone has a conflict of interest or has to remove themselves for another reason. And there were a lot of conflicts of interest and not all of those were addressed. But one of the reasons that Quig Lawrence was on the trial court is because he was an alternate. And I found that really interesting because back in 2022, he posted on Facebook about Joanna and said, sometimes the helper and advocate is a wolf. Having bishops with that kind of perspective coming into Judge Stewart just seems a bit problematic.
I don't even think he was an alternate. I think he was appointed. So we assume that Steve Wood appointed him. I don't believe he's listed on the list of alternates. I think they ran out because of recusals.
Oh, okay. Thank you for correcting that.
And just to be clear, for those that are, we can get lost in all these details.
Absolutely.
Bishop Quig Lawrence wasn't originally on the tribunal. Is that the correct term for this? For what he was on?
He was not on the trial court.
Yeah, and so I think the assumption is made that other bishops recused themselves, and
Correct.
then therefore others, and this would be where Bishop Quig Lawrence would come in. He was then appointed or maybe volunteered himself. We, of course, don't know what went on behind the scenes, but that's essentially what happened, right? That we know of.
Yeah, when we look at the signatures in the final order, we see that Peter Manteau and Alan Canapel were not a part of the trial court, so we assume that they recused. We don't know for what reasons or when it happened, but I don't believe Quig is even listed as an alternate. So he was appointed, and I believe by canons that would be by Archbishop Steve Wood. But yes, we have this very apparent, post on Twitter, or I'm sorry, from Facebook from 2022, where Bishop Quig Lawrence is directly attacking Joanna and her credibility. And by extension, ACNAtoo, and all the survivors and victims, and yet he gets to sit on the trial court and determine, if there was any misconduct or mishandling or canonical
Or
violations.
narrative capture.
Or narrative capture. That is just ludicrous.
I'd like to talk about Jeff Weber. Jeff Weber is an attorney. He's based in North Carolina. So just as Quig Lawrence is bishop in the Diocese of Christ Our Hope under Bishop Ordinary Alan Hawkins, Canon Jeff Weber is connected through Bishop Hawkins, through Church of the Redeemer, and through other ministries in Greensboro. There is a blog post by William Bartow, who is a chancellor. He is an ACNA priest in the Reformed Episcopal Church. He would say presbyter, I think. Hi, Bill. And he has a post as a former judge. He was a military judge. He was an appellate judge for many years. He has done litigation. He was not asked, by the way, to serve on this court in any capacity or to serve as the prosecutor, which tells you something about the standards of the ACNA. He has a post on his Substack called When the Case Hits Too Close to Home. And it's about what is problematic with Jeff Weber being appointed as the presiding officer of the court, particularly given the controversy surrounding the misconduct of the court alleged by the prosecutors who resigned. It is likely that Weber may have been the person whose conduct that Alan Runyon and Rachel Thibault objected to when they resigned. And furthermore, it seems that Jeff Weber was probably the main author of this verdict, or of the final order, as they're calling it. So Weber himself was disciplined by the North Carolina State Bar for professional misconduct. And the Substack details some of those concerns there. He was not ultimately disbarred, but it's very clear that he did some extremely wrong things in terms of not respecting client confidentiality. You can find the documents online. So the reason this is a conflict of interest is that you wouldn't typically have somebody on the court who is accused of something that is similar to what the defendant is accused of, because they're going to be overly sympathetic towards that person. So I highly recommend that blog post and looking into some of the professional problems with this guy. It raises questions generally about his competence. So just want to highlight that one as one of the most problematic conflicts of interest here.
Somebody just put up a really interesting question, and I think it's very valid and very fair question, which is, okay, we have this small denomination. Everybody's going to know somebody. There's going to be some connection somewhere. What do you guys make of? How do you avoid even conflicts of interest in a denomination of our size? Is it possible? Was that an unrealistic expectation? How might you respond to that?
I think that's a really good question. I think we need to have more lay participation. I think when you only have 28 active ordinaries and, between 40 and 50, if you count the suffragan and assisting bishops, that is too tight-knit of a group to be leading something that includes, that is responsible for the accountability of one of their own. So I think we're almost seeing in the new canons, the revisions, almost a bottleneck of let's have fewer, let's only have 3 bishops in charge. And it's no. Really, the bishops should not be in charge of holding each other accountable. They've already demonstrated historically that they're fairly unable to do that and unwilling. So I think bringing in lay and even perhaps lower clergy, don't bring in the canon of your diocese. Don't bring in the person that works directly with the bishop who's best friends with the bishop in question. Yes, there's going to be a lot of conflict of interest, but it is not unavoidable. We have a denomination that is roughly 135,000 people. We can pull in people with expertise. There are people with legal expertise. There are people with canon expertise who, let's just say, Anglican podcasters have called canon hobbyists. But you know what? Sometimes canon hobbyists actually are very useful when we need to pull down those thick tomes off of the bookshelf and open them up and say, what in the heck do we do right now? Rather than grabbing Bishop's good friend who he visits with on a regular basis and who will then testify in the trial that we know from firsthand experience how he governs. That's ludicrous.
There's no transparency in any of these processes. You're not seeing transcripts of this. They could redact sensitive survivor information on these transcripts. They're not showing their work at all in this final order. They're just asserting things, dressing it up in legalese, and not giving us any sort of list of what were the actual charges, what was the evidence presented, why do we not think it met the standard? If you want to demonstrate that you are objective, you could just be more transparent.
And I was going to say, with somewhat of a gleam in my eye, is maybe it starts with us acknowledging that we're all prone to narrative capture. So if we're going to hold a trial about church abuse and mishandling, okay, well then let's have 50% of us given over to the narrative capture of being pro-bishop. Okay, and then the rest of us, 50%, are going to be very adamantly pro-survivor, pro-victim, and advocates. At least then we can acknowledge that, hey, we're coming at this from different perspectives. I think the problem of the conflict of interest question, it's like kind of like as you described, Audrey. Oh, this guy was a friend. He worked with so and so. Da 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 da. There was no ACNAtoo member asked to be on the tribunal itself, even as a lay member. Why not? Why wasn't somebody that, the trial order described you as, online advocacy groups? Dare I say, some of you are experts in your field now, albeit in an unofficial capacity. Well, even if it wasn't you, was there somebody in a similar realm that could have assisted the trial in that way? Why weren't they asked? Right?
Yeah, and I think it might be helpful to remember that Chad Graham comes to mind, the first prosecutor that was assigned to the Ruch case, and then who removed himself. I forget the reasons, but so he has a number of Substack posts about this, and he basically says something along the lines of, we can either have, the ACNA can either choose a policy route that is responsive to advocacy, or we can have a canon law approach that is objective. And I call logical fallacy. That is a false dichotomy. I think one of the things that we tried to address in our response to the verdict, and I think is worth repeating, is that everyone benefits when we have a process that is transparent and open and that actually provides due process. This outcome for Stewart, it might feel great to him right now, but down the road, as people look at this, they're going to see, they're going to read the verdict and be like, there are going to be questions. People are going to be like, well, was Stewart really guilty and he only, was acquitted because of this sham process? Like, if Stewart actually wanted to be vindicated, this is not the process to do it, because it's such an obviously rigged process that it's not like, you can't point to the process and be like, yay, like I'm innocent. Like that's not what's going on here. And so it actually would benefit him to have a process with an actual independent third-party investigation. As Sam was saying in, I think, the last episode that you did, Chris, like the point of public trials and hearings is to protect the defendant and to protect people, so that they get a fair trial. And instead, all of this was shrouded in secrecy, and that does not benefit Stewart, because nobody knows what went on there. Was he actually vindicated? He can't prove that he was.
They did say in the trial order, we went through 7,000 pages of evidence, and then that's another logical fallacy, meaning, hey, we looked at all the evidence and thus we concluded he's not guilty of anything. But they didn't actually address what was in those. You all, over my time with you love Venn diagrams. At least some of you are really good at making them. So somebody says this. I don't know how you want to comment on this, but this is kind of fascinating. It says, so now we have a Venn diagram of ACNAtoo, the Upper Midwest Diocese, the UMD, and the province. They agree that the ACNAtoo are a woke mob. We and the UMD agree that the system is broken, meaning that so much in the trial is pointing to just issues with how the province itself handles abuse allegations, trials, all of that. The province, and then in parentheses says whoever that is, and ACNAtoo agree that Stewart Ruch is causing massive problems within the diocese, right? Anybody want to make a comment on that Venn diagram and kind of where that leaves things?
I mean, after the final order, I would add a fourth circle, because the disposition of the court, if we are to take the final order as representative, they all signed it, is that the province is the problem. Most of the final order is spent on how dear Stewart was persecuted by this incompetent province, along with these evil lives in ACNAtoo who are hysterical and exerting narrative capture. The province was not doing a good job in seeking to hold Stewart accountable. We have been saying since the beginning that the moves that the province has made lead to obscure Stewart's actions and the actions of UNT leadership. The structure and the choice of investigators in these firms is not at all conducive to transparency. These investigations were not safe. The scope was not clear. Everything in how this was conducted was to minimize liability on the part of the province and on the UNT. So we would agree, province, extremely incompetent, not acting in good faith. So these guys are just fighting amongst each other, and they're trying to offload the blame when they are all leaders in this system. They all failed to prepare for this, and they are throwing a perpetual pity party of the persecuted. So their entire vibe is, if anybody criticizes us, it's because we're orthodox. Look how sincere we are. We have good intentions. We didn't intend these bad things. We said we're sorry, even though we've done nothing to inform ourselves, and we only listen to lawyers who tell us what our itching ears want to hear. We should not be held responsible, even though we failed repeatedly and took no steps to prepare ourselves to try to repair the harm we've done, to try to become people who wouldn't do this again.
And I'm sure the province would say the same thing. The province would say, yeah, that's also the online circles they're the ones spinning the narrative about this, right? So it's just you're gonna get caught into an endless blame shifting loop, right?
Well, I guess I wanted to speak to my own personal frustration as I read the final order. I just came down to this was not playing fair whatsoever. So we've already touched on this before that, there were 3 investigations, no long-term published report. Even Hush Blackwell was out less than 72 hours, and Polden never returned. GRS we were never given access to that report. Telios never given access to those reports. We have no published court motions at all. So we don't know how the trial was set up. We don't know what happened in pretrial at all. We have no released transcripts, and those can absolutely be redacted. So we don't know what happened in the hearings. We don't know if or what evidence was considered. They always do these broad sweeps in the final order. We looked at the evidence. What evidence? And there's multiple times, which of course I'm going to gnash my teeth at, because I was part of the team that authored, carried forward, worked with survivors directly, and then signed the presentment, the lay-led second presentment. And there's multiple times where they just say, the evidence failed to condemn or whatever Ruch's canonical violations whatsoever. And I just think, how? There's no explanation. It's just this broad sweep of well, it was a nothing burger. That hurts. I think personally, for somebody who has walked with survivors since July of 2021, and here we are 4.5 years later, to have this all just swept off and concluded to be this online advocacy narrative capture, social contamination. And I think some of you in the ACNA know me better than that. I get that there are people who've never met me, never met us as a team, but there are people that know us, and that hurts that there's no outcry over that description of what we have done. We have done really, really hard work to sit with survivors, look over their evidence, and then midwife that evidence into the presentment, where we were able to weave together patterns and say, look, the bigger picture here shows that we don't care. Canonically, it doesn't matter whether Ruch had willful misconduct. Willful is not a canonical term that you're going to find anywhere. That is a term that the court reinterpreted. And they said, well, he didn't mean to do any of this stuff. Just in the first month after Sharon's report of her daughter's disclosure, Ruch, we have an email where he is specifically saying we need to find legal defense for the accused. And he appoints his chancellor to try to do that in an unofficial capacity. That is in the Hush Blackwell report. That is firsthand evidence. They don't have any firsthand evidence. We have an email written by Bishop Stewart Ruch specifically trying to find legal defense for the abuser. We also have an email that, again, is in the Hush Blackwell report, the report that was pulled in September of 2022, where he is writing back to Father Van York, one of his priests, saying, yes, I give you permission to approach the family and encourage them to drop the criminal charges, as long as it doesn't appear to be pressure from the church. I mean, that is just, from any angle you look at it, that is wrong. So if the court is going to say, well, we looked at all the evidence, I don't know, did you? And we decided that it wasn't willful, like this is how bishops grow, this is how they evolve. I don't buy that. That's not canonical. And what the second presentment sought to do was say, since 2019, we have seen a pattern continue where he hasn't learned. He hasn't grown. He is still continuing to make mistakes. He's still continuing to put people at risk in his diocese. As one of the authors and as one of the people who work directly with survivors, I just feel completely abandoned and misrepresented. And the fact that we don't get to read the transcript, we will never know unless that trial transcript is revealed. We'll never know whether they considered that evidence at all.
Regarding that transcript that we'll never see. So and we're going to get to this in a little bit, like talking about what role did you all play? What role did survivors and victims play? Were they giving their testimony? One of the big portions of the trial verdict, it wasn't a list of going through the evidence of here's what's addressed in the presentment. Instead, they spent a big section on here are 3 bishops that know Bishop Stewart. Here are 3 other bishops. And that, to me, when I started reading that, I was like, oh, this is whatever the definition of a kangaroo court or whatever that term is. I go, oh, okay, so this is just a bunch of people gathering together and just saying, yeah, this is my guy. I like my guy. Leave my guy alone. Okay. Oh, okay. Yeah, that's right. You're right. We will leave your guy alone. So it didn't actually go through, like you say, Audrey, all the work that you all have done. It didn't address all the work that was in both presentments, right? It didn't go through that. Heather, did you want to say something quickly? Then we'll go to Whitney.
Yeah. Audrey used a phrase, well, Stewart didn't mean to. He's the bishop. It's not enough that he didn't mean to. It is his job to mean not to. In almost every system that mishandles abuse, leaders let each other up if they recognize that the person was sincere, had good intentions, and had right doctrine. There is a functional epistemology here that I'm going to have good judgment as long as those 3 things are in place. Do I believe the right things? Am I sincere maximally? And do I want good things to happen? And there can be a hubris with that, as if all of reality should be available to me. I should already be equipped to be a good judge of these complex issues, even if I have no relevant theoretical background, even if I have no practical expertise, even if I was formed in a system that has repeatedly failed, and that system is led by other people who are just like me. So sincerity tends to be treated as a proxy for the Holy Spirit. That if I recognize my own sincerity, if inner witness bubbles over with my good intentions, and I see that my friends also have good intentions, then surely that is the Holy Spirit making sure we aren't going to mess this up really badly, and we don't actually have to do research or listen to anyone else. And if somebody, say the hysterical lids, are pointing out problems that we didn't consider, well, we are reasonable men. Look at our good doctrine, look at our good intentions. If this really should have been a priority, if this was really a big deal, if abuse was really this common, we would have thought of it already. These concerns are just illegitimate and hysterical and come from wokeness rather than actual diligence in informing ourselves and understanding how abuse response has gone wrong in other systems. Repeatedly throughout this final order, you see these maudlin, sentimental characterizations of dear Stewart and his magnanimity, his humility. And this is treated as just evidence in and of itself, as if people can't fake sincerity. Now, firstly, I don't think Stewart fakes it. I think he means it, but I think they all let each other off the hook as long as they mean well. You only get to do that once. And really, if you're a bishop in this context, in which people have repeatedly failed, you're already on notice with all these other scandals in churches. Stewart could have and should have prepared himself better. The original ACNAtoo advocates that came forward long before any of this went public, they would have been so willing to forgive Stewart if he actually showed repentance, instead of just expecting a sentimental apology that actually did nothing to repair or change his course or demonstrate that he was informing himself to do better. Like, they would have totally forgiven him. He could have come out of this a hero. But instead, he completely abdicates his responsibility to inform himself and do better, and he makes the same mistakes over and over and over.
I was going to read the quote that just came in. This person writes in, "This would not be an acceptable excuse for malpractice from a doctor." They write, "I'm not more excited to see a sincere but incompetent doctor than I am to see a malicious one. Either one could harm me." Reading the final order, my heart just like exploded because I thought they are all saying that what he did is okay. And that is just leading to a precedent that what any bishop does, if they follow in his footsteps and do any of this stuff, it's okay. It's okay. They meant well. They're growing. They're learning. They're building the plane as they're flying it. That is not the church as it was meant to be.
Yeah, I wanted to hop back in on some of the things that Audrey was saying a couple turns ago. One thing was in the specific reference to the mandatory reporting, or mandated reporting, however. I always switch which word's supposed to be used for that, but the same meaning. The final order, it changes the timeline in order to specifically avoid that issue. It leads with the problem began in 2021 or 2020, but it completely sidesteps. No, the problem began when a 9-year-old reported abuse and none of the people who were told about it reported until her mother did. Like, it just completely sidesteps. This is why we're here. This is what we're talking about, is one of the primary issues that is coming up, and why this trial is happening is because Stewart Ruch and the people under him failed in their obligations as mandated reporters. And that is just completely swept aside, both in what the final order covers in its references and in the timeline that it provides to us. Like, this is the time that we are covering, which, no, that is not the time we're covering. We are covering what the inciting incident was that led to him being on trial. Another thing I wanted to talk about was regarding the conflicts of interest and how so much of this has been presented as, oh, these advocates have such a bias, and these people online have such a bias about when they're talking about people in ecclesiastical authority and things like that. The report that they allow as their primary point of evidence, and I believe we've referenced this already, but was led by Teresa, who one of her children was attending res for years, was a long time attender, and multiple people in the lead up to this investigation raised that issue with Teresa, raised that issue with the province, raised that issue like wherever we could get people to listen to us. But that report went forward, and that bias was considered acceptable. But any bias that has to do with, well, you're too close to survivors, or you are too close to the online narratives, that is considered an unacceptable bias, whereas having your child be a longtime member and supporter of the person who is going to be on trial was just fine, which is coming back to everything that the online advocates say is hearsay, which is another thing that I think has come up a lot in that. Whereas, like, we can point, like, go look through anything on the website. We link to primary sources for pretty much every claim that we make. We vet everything. We will link out to things and show you our evidence and show you our work. And you don't see any of that, as Audrey was saying, in the final order, where we're not told, look, what evidence? What is it that was not sufficient? Give us these transcripts so we can see your work.
Well, I was just going to say, it's really funny that, solidly through these last 4.5 years, and even before, when before ACNAtoo was even a thing and it was just a small group of survivors, we have asked for transparency. If we had something to hide, we wouldn't be asking for transparency. And we have consistently throughout this entire thing. Let's lay out all the facts. Let's, speaking of firsthand evidence, we have it. It's here. Would you please look at it? That's why ACNAtoo started.
Right. And I'd like to add too, the culture of the College of Bishops is a bunch of men who receive every critique as persecution. And they are constantly smear campaigning the ACNA to each other. Some of these bishops have not done the most basic due diligence to inform themselves of what is going on. They will take the word of any of their fellow bishops that this is all blown up. It's all just libs who are out to get us. It's all hysterical, unreasonable people who aren't using evidence. We're also reasonable. They haven't assessed any of the evidence that we've presented. They haven't listened to survivors, but yet we are presented as biased and in an echo chamber. They live in their echo chamber. They cannot afford to hear the people who are pointing out what they're doing, because they would have to rethink their entire lives if they had a bit of integrity, and they're not going to do that. Whitney, you brought up Teresa Sidebotham of Tellius Law, and you mentioned how problematic it was that she had a child who went to res for many years. But there are many other problems with Tellius Law as an investigator that we should note. These are public, you can find them. Look up how Tellius Law, Teresa Sidebotham, when she was working for iHeart, that's IHART, handled the Ethnos 360, also known as New Tribes Mission, investigations into historical abuse. This is a notorious case. If you want to create a whitewashed investigation for a church and dress it up with some Bible verses, Teresa Sidebotham is the right person to hire. We have documented concerns with how Tellius Law conducts investigations, with the lack of transparency, with the misrepresentation, mischaracterizations of participant testimony. There are multiple instances in the ACNA now when Tellius has done this. I would point to the Dan Alger Church of the Redeemer case at Alan Hawkins's Cathedral in Greensboro, North Carolina, as the most recent example. If you look up Rebecca Hopkins's Substack, she's an investigative journalist, and she shares her own experience of interviewing with Teresa for an investigation into Mission Aviation's Fellowship. There's another testimony by an attorney named Libby Mickey Coles sharing her concerns about the incredibly messed up ways that Tellius Law and Teresa Sidebotham handled an investigation in her church. And we, of course, have our own testimony there as well. This is not somebody with a sterling reputation. She's somebody who has been called out repeatedly for institutional protectionism. She tells these people what their itching ears want to hear. And as long as members in organizations like the ACNA are easily seduced by sincere sounding rhetoric and a little dusting of Bible verses here and there, they're going to continue tolerating these sorts of incompetent investigations where she is not only investigating, but is being brought in as an expert witness, supposedly for the province, who is supposedly prosecuting this. And they're going to let these guys off the hook with incredibly bad arguments on topics that she wasn't even hired to investigate.
Okay, I want to stick with Teresa Sidebotham for a little bit, and then go somewhere else, and then I want to let people ask their questions, because there's a lot of questions coming in. I think what I want to do, and I just want to acknowledge this, because this is going to be going out to lots of people, right? We've introduced a new character into our narrative. And so for those of people, they just hear about Mark Rivera in an abuse case and Sharon and her daughter. Now, all of a sudden, there's a new character. And as Heather mentioned, who could take in all of the list of all of those cases that she just mentioned? Can one of you unpack just a little bit about who Teresa is and what is her typical role and why was she even brought on to the UMD's case?
Okay, so Teresa, she was a missionary for a number of years. I actually met her son at Wheaton because he was there when Audrey and I were there. So I knew him. And Teresa is also a Wheaton grad, as well as a number of the people who were accused of various misconduct and mishandling at Res because of the Wheaton Res overlap. So Teresa currently has a law firm, Tellius Law. She is also a big part of the evangelical ECAP. What does it stand for?
Evangelical Council on Abuse Prevention.
Yes. So Teresa had a big role in starting ECAP. Ostensibly, it is a way for churches to go through a safeguarding process and become certified by ECAP to say, we have done all the things to reduce our liability and we will keep your kids safe. What it actually is, in my opinion, is an organization that if you pay them money and go through their process, you probably will come out with some better policies, but they also give you some advice that will protect your church at the expense of victims. It's problematic, but that is something that organizations and churches that have brought Teresa and Tellius in have also complained about. Teresa is very much on the side of the institution. And so I actually emailed Teresa back in February of 2022 when the ACNA announced that Tellius was going to be the law firm. You know, Sidebotham is a fairly unique name. So I saw that name and I was like, hang on, I know that name. And so I emailed her and I was like, I'm really concerned. Here are some of my concerns. Here are some of the things that I hope that you would do. And I said, we would really like to see the letter of engagement or the contract, because this is how survivors will know that it will be safe to participate. And I said, the fact that you led a Wheaton alumni chapter indicates to me that you're invested in, Wheaton alumni, and you're going to be investigating mostly Wheaton alumni. Tell me about your process. And she emailed back and basically said all of my concerns were unfounded. She said sharing the letter of engagement is actually not current best practice. And she also said our general posture is to receive any allegations, not to limit what we would receive, which is an interesting comment given that we actually have talked to witnesses who wanted to offer evidence to Teresa, and she said, that's okay, we have enough now. So just kind of comparing those two things is really frustrating. And then I said things about, how are you planning on contacting people outside the ACNA? Because as we know, a lot of times, especially with spiritual abuse, people have really traumatic experiences in church and then leave, and they're not going to be reached by like the typical ACNA email list. How are you planning to do survivor outreach? And she was like, well, I think probably people will hear about it word of mouth. And, if you have any other suggestions, just, let me know. And I was just like, okay, so here are some suggestions. And then, of course, she never followed any of those suggestions.
Whitney, do you want to follow up?
Yeah, I was just going to kind of piggyback a little bit on that, because a lot of what we've been saying is like, here are some of the exterior things. Just like as an example from within the process of the Telios report, I went in and spoke to Teresa at one point as giving testimony for this investigation. And one of the primary methods that she used was you would talk for a long while, and then at the end, she would rattle through a list of names. And she would ask, rate this person's trustworthiness on a scale of 1 to 5. And you were supposed to go through and I think it was it was either 1 to 5 or 1 to 10. I can't remember what the numerical scale was, so don't want to be like misquoted on that. But the way these were compiled were things where if you went into this seeking anonymity, that was pretty much going to throw that under the bus, because while she would say, we've just pulled all these names at random, things that we've heard people mention, this, that, and the other, there were some names in the list that she told me of people who would not, like, there was no reason for them to have been mentioned in any other capacity than they had come and made a report. And that just carelessness with survivor anonymity and basic best practices of protection and anonymity is why so many survivors felt deeply unsafe engaging with this investigation at all. And those of us who did come forward, I feel like we're often weaponized as reasons to invalidate it. Like, for example, like I went forward saying, hey, I didn't really experience anything firsthand that I would consider extreme enough to be counted as part of the cases of abuse or anything, but I experienced things that exhibit the same patterns. I would like to tell about my experience of these patterns because I think these can be used to support what later happened to other people in a higher degree. The things that I brought forward were counted as accusations and were therefore easily disproven on that ground and used as a reason to then disprove later ones, which for one thing is misquoting the entire context of what was given to her and is also just very careless work. But if it helps to have some more concrete examples of what that exact process of the investigation looked like, the trustworthiness ranking especially is one that has really stuck with me.
One thing I just want to make sure I clarify for everyone's sake, and then you can, maybe Audrey, you can just touch on this briefly before you can go into what you want to say, is Grand River Solutions was hired first by the Upper Midwest Diocese. Is this correct? Yeah. And so then you can maybe touch on then Teresa and Telios Law, where they came in, and then also to say, hey, have we actually seen their report? And the reason I say that, and you can answer that, Audrey, is because she is used as the primary testimony in the final trial order that has been released. And this will lead to my next question, which is, where are the testimonies of the survivors, of people, of online advocacy groups like ACNAtoo? Where is that in the trial? And maybe you can touch on why that's not there. We'll get there in a minute, but just clarify the Teleos report and then how that was supposedly used by the province itself, Audrey, and then you can go into whatever you were going to head
Yeah.
whatever direction.
Interestingly, the three members of the provincial response team, Autumn Vandehei, Gina Rose, and Kristen Price, who resigned in mid-January of 2022 after only about 5 months serving on the provincial response team, and immediately after Hush Blackwell was announced, they didn't choose Teleos and didn't really know. It was very quiet about why the investigation was being bifurcated into just sexual abuse, mishandling, misconduct, violation allegations, and spiritual abuse, or what they called ecclesiastical abuse of power. Alan Hawkins reportedly told them that that was a suggestion by Diane Langberg, who is an expert and specialist in spiritual abuse and church abuse. She has denied this. Anyway, long story short, while we on the front end were being told that the provincial response team was selecting and vetting these firms, we have the testimony of these three women from the PRT who resigned saying, we never chose Teleos. And yes, that report was never published. It was never promised to be published. In some ways, it like created this vacuum for all things not Rivera and like LePere and Keith Hartzell, and then just put them off in this corner where nobody will ever see them ever again.
And when the trial order is now just released, this is the first that any of us are even seeing any of Teresa's actual reporting. But even in the trial order, you're not actually getting the Teleos report. You're just kind of getting paraphrased snapshots of what she said. Is this correct?
Exactly. Yeah, we still know nothing from the Teleos report, and we're not exactly sure why the province chose Teresa Sidebotham to be their expert witness. That baffles me. I would not have chosen her. That said, I don't know what Alan Runyon, who would have been the prosecutor during that selection time, I don't know what his intentions were to use Teresa. Again, because we can't see the trial transcript, we don't know what questions he was asking her and what information he was wanting to put forward to the court. I just don't know. It does appear from the final report that and also from Runyon and Rachel Thibault's outcry that the way the court used her or exploited her during some kind of improper questioning, again, we can't prove because we don't know the motions, we haven't seen anything pre-trial, and we don't know the court transcript. But it seems like this debate back and forth is that she was improperly questioned. And then, yeah, it looks horrible in the final order. It basically looks like she's giving a shining gold star to Stewart and saying, like, plow on. That's really, really frustrating.
Can I point out one of the sillier things that she says?
Yeah.
So one of the things they discuss her testimony as supporting is that, organizations at this sort of level of development don't typically put in child protection policies up to a certain point. And they're like, oh, who could have expected Stewart to know? Well, this is really silly. It's not like organizations are this sort of natural organism that is going to develop a certain way, and you can't expect anything more from this. What we could expect of church organizations now is different from what we could expect 10 years ago. They should know better now because we know a lot more. There's a lot more resources available. This is not some sort of constant pattern or blueprint of how organizations should develop. And even if it were, it doesn't mean that they're not morally responsible for setting better standards, especially when they could and should know better.
You had asked about witness, survivor and witness testimony.
Yeah, I think let's make that the next big section. And I guess I'm curious how you all respond to that. What do you want to say about your own role in this? I mean, Audrey, you helped to write the lay-led presentment. Is this correct? Right?
Yeah.
So what can you say about, I mean, I know there's a lot there to unpack. So where do you want to start us off?
Yeah, at the time that we started writing the lay-led presentment with former current members of the Upper Midwest Diocese, it was about early March of 2023. So I had already walked alongside survivors for a little over a year and a half, would that be? Almost 2 years. I had already done my own faux pas of believing that the province was acting in good faith and bringing survivors directly to them and then watching them be mishandled by leadership. And so I wanted to really, really carefully, as we put this presentment together, handle survivors with care and protect them. I just didn't want to repeat past mistakes where I had told them, don't worry, you can totally trust this process. Everybody has your best interest and they will protect you, and then have it not happen. So we submitted the presentment in June of 2023. It was declared by the Board of Inquiry that a trial was warranted in August, I believe August 15th of 2023. And in September, I wrote to the provincial office and said, hey, I'd love to know, what is the trial process? I need to prepare survivors so that they know what to expect and what will be expected of them. That email went unanswered completely. They never would respond to me. We asked questions of Chad Graham. We asked questions of Alan Runyon. At no point were they willing to tell us, this is the way a trial in the ACNA runs. This is what will be expected of survivors. This is how either their identities will be protected or their sensitive information. We asked about, how can we submit evidence that is more sensitive, that we purposely didn't put in the lay-led presentment because we knew that it could go public. Though that was never answered. And so in the course between submission in June of 2023 and in like December, January of 2024, as we're still in the pretrial process, never could I get any guarantee that survivors would be safe, that they would be protected, that they would be cared for well. It was a very sterile kind of like, we're doing this, and if you can participate or not. And that's just not safe. So basically, communication with the prosecutor stopped after December of 2024, and he obviously plowed on and didn't need our assistance, despite the fact that we had contact with all survivors and held this, huge, vast amount of firsthand evidence. Yeah, I mean, there still was, I believe, one survivor who participated, and their testimony was mischaracterized and misrepresented in the report. There were two signatories that I think the final order says that they had no diocesan leadership. One of them led the Minnesota Deanery for child protection policies and helped revamp the child protection policy. The other one served for almost 2 years on the diocesan, what's now standing committee, what was the Bishop's Council. So it's just outright lies in the final order. They didn't have leadership. They absolutely had leadership, and one is ordained. So yeah, the fact that they didn't call any of the rest of us as witnesses and were unwilling to explain the process, I don't think that they have a process. I think they create it at will. And I don't think that they like to lay out their process because they want it to be fluid. They want it to be kind of like this abstract painting of let's put this color on the palette, So that's really frustrating. Again, I would love for there to have been survivor testimony. I would have loved for us to have so many more voices. I can't remember the numbers. Was it 11 or 12? I think it's 11 people were brought forward as witnesses from the provincial side, from the prosecutor's side, and I believe 26 from Stewart Ruch's side. Again, that is ridiculous. And there's multiple pages where it's former Dean Steve Williamson talks about Stewart's character. He's paid by, he was on staff the entire time. And then current staff members speak to his character and the way he leads. And it's none of that is material to our investigation. None of it is material to the trial. You don't have the voices of survivors and their advocates. And you really don't have women's voices at all outside of Teresa, and at least named, which again is just kind of crazy. Because most of the survivors are women. It's just an observation.
If you make it clear that you think the survivors and advocates are trash or hysterical or exaggerating, if you make no provision for transparency, if your institution fails repeatedly, and you don't demonstrate how you are improving other than saying we take abuse very seriously, you can't expect them to trust you enough to participate. And this has happened at every step of the way from the investigations onward. And if you push out survivors so they don't participate, you don't get their evidence. So even the evidence that was collected by Hush Blackwell and GRS, for instance, was downgraded. They spent an enormous amount of money on these investigations. And they didn't use them, and they certainly did not engage them properly in this report. But they let Teresa, who was commissioned for this completely non-transparent investigation, speak to all of these charges against Stewart as an expert witness and as an investigator for the spiritual abuse allegations. And the investigations that were done into the other charges were not handled. In those investigations themselves, the scope was so limited that Hush Blackwell couldn't even comment on things like whether or not the UMD leaders like Stewart had failed at mandatory reporting requirements. So how are they weighing this evidence? What counts as evidence? If you block survivors ahead of time, so there's no safe way for them to participate, you're not getting their evidence. If you then refuse to engage the evidence in these other investigations that indeed were problematic, but were better than Telios, that evidence is not going to be involved in court. If you behave so inhospitably and hostilely towards survivors that they cannot participate in the trial and aren't even invited to participate in some cases, their evidence isn't going to be present either. So they use all this pompous legalese about evidence and facts. They don't engage the particulars of the actual allegations and demonstrate how each one was not supported by evidence or talk about which evidence was there. They just lean on Teresa and a bunch of bishops who, of course, empathized with their buddy because they would have done the same thing.
Think about this. If you read the trial order, do a word search for firsthand, typed out as one word, firsthand. What you'll notice most every time that word comes up within the trial order, it is under the assertion that none of the allegations against Ruch came from firsthand knowledge, or at least those presented especially in the bishop's presentment. To quote from page 17 of the order, rumor, online advocacy, and social media narratives profoundly shaped perceptions of events, expectations of episcopal wrongdoing, and pressure on the province to act. Yet none of these influences produced evidence or were grounded in first-hand knowledge. And later on, from page 19, the testimony further establishes that the decision to proceed with that presentment was not unanimous within the provincial investigative team, abbreviated PIT, and that at least 2 members objected to its issuance. Notwithstanding those objections, the presentment was ultimately signed by 3 bishops who, according to the record, possessed no first-hand knowledge of the underlying facts, did not conduct direct inquiry of primary witnesses, and did not themselves participate in the original third-party investigation or its fact-gathering process. And then, from page 24, even the most informal investigative process ordinarily includes direct inquiry of those with first-hand knowledge. The absence of such inquiry here underscores that the process was not merely extra-canonical, but fundamentally non-investigative. And then, quote, it supports the conclusion that while a board of inquiry may have existed nominally or declaratively, the investigative function was in fact absorbed and controlled by a provincial group operating without direct fact-finding, without engagement of first-hand witnesses, and without any demonstrated canonical structure. This collapse of the assumed process into a highly fragmented assemblage of extra-canonical voices comprised of multiple third-party investigative actors, provincial staff, an internal mourning team, and an extra-canonical provincial investigative mechanism, among others, bears directly on the integrity, legitimacy, and evidentiary reliability of the proceedings that culminated in the presentment, and cannot be dismissed as collateral or immaterial. A severe lack of first-hand knowledge, they claim. What you've just heard from ACNAtoo in this episode lays out exactly why the trial investigation lacked first-hand accounts. Added to this, the court refused to consider the evidence given in the lay presentment. Note, essentially they were looking at the bishop's presentment only and the testimony of Teresa Sidebotham. But the lay presentment was primarily first-hand accounts, first-hand knowledge. A link containing those primary sources, emails, court documents, police documents, etc., will be provided in the show notes and on ACNAtoo's transcript page for this episode. But along with this, what perplexes me is the trial seemed to rely almost solely on the testimony and insights of Teresa Sidebotham. Indeed, it seems, along with the 3 bishops who testified in defense of Stewart Ruch's character, their verdict was primarily based on the narrative Sidebotham captured for them. Where was her first-hand knowledge? And again I say, where is the due diligence? And did the trial court expect anyone with a discerning mind to take their final order and the verdict that came along with it seriously? The second part of our conversation, with questions from listeners about the Ruch verdict, continues in the next episode. If you believe in what the Wall of Silence podcast is trying to accomplish, please consider supporting us through our Patreon page at patreon.com/Wall of Silence podcast. Though I am not able to offer extra material every month, every now and then I do put up an extra episode with surplus segments from interviews and conversations we've had. There won't be one this month, but look back at our backlog. There are some good ones on there. No matter how you support us, I very much appreciate you and how you help to make this show a reality as we lift up the voices of church abuse and survivors in the Anglican Church in North America. And as we deal with the aftermath of this trial and how many of us have had our hopes deferred once again. The Wall of Silence podcast is produced and edited by me, Chris Marchand. I also record the music, and our artwork is by Alice Mitchlick. You can find her other work or commission a piece through her Instagram account, Mouthful of Stars. Please rate and review the podcast on Apple, Spotify, or whatever service you listen to. You can find a link to the transcript of this episode, including related article links, in the show notes. Thanks for listening.